and mandate of the courts is to apply and enforce the laws of the Republic, and not to grant persons immunity from criminal investigations and prosecution. A court cannot injunct the OSP from investigating or prosecuting any person. The decision to investigate and prosecute lies with the investigation and prosecution authorities, such as the OSP, and the OSP has at all material times carried out its power to investigate with candor and professionalism, being minded of the rights of suspects under its investigation. Members of the press, just as it is essential that anyone accused of a crime should have free access to the courts so that he may be duly acquitted if found not guilty of the offense with which he or she is charged, it is also of the utmost importance that the judiciary should not interfere with investigation and prosecution authorities in respect of matters which are within their statutory powers. It will be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated, who should be prosecuted, and who should not. That is not the function of adjudication. The danger of this startling decision is again quite obvious. A judge has in the process granted two persons immunity from investigation, and in effect, immunity from prosecution. This decision opens up a calamitous deluge, as every person under criminal investigation will be encouraged to take out suits to injunct investigation and prosecution bodies from investigating and prosecuting them. Indeed, there's a live case involving the OSP now, in which someone has taken the cue to seek to injunct the OSP from investigating them. The real and present danger looms largely on the consideration that by so doing, persons under investigation would end up conscripting the judiciary to clothe them with immunity from investigation and prosecution. Members of the press, I do not intend to sound as though I'm predicting doom, but we are facing doom. I do not intend to sound as though I'm predicting doom, but we are facing doom. There appears to be a developing trend of rather regressive and dismissive judicial decisions in respect of cases involving the OSP with troubling consequences. And it seems to us that a careful examination of these outcomes portends a disturbing specter that the fight against corruption is being hampered to the disbenefit of us all. For a public officer to have such large cash sums stashed in their homes, and that the circumstances of the case dictated pause and reflection, and the granting of the OSP adequate time to carry out its investigation. In our estimation, the judge was only interested in the return of the money to the person of interest and nothing more. Then he proceeded to erect non-existent legal barriers to prevent the OSP from investigating the matter. It is also of the utmost importance that the judiciary should not interfere with investigation and prosecution authorities in respect of matters which are within their statutory powers. It will be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated, who should be prosecuted, and who should not. That is not the function of adjudication. The person, through his lawyer, proceeded to the Human Rights Court on an ex parte application, and the judge, without even an inquiry as to why the OSP believed him to be a fugitive from justice, issued an injunction that the OSP should not arrest the person for a period of 10 days. Members of the press, this is dangerous. It encourages criminal suspects to go before the courts to seek injunction orders against law enforcement agencies from apprehending them. The judge did not advert his mind to the well-founded proposition that no one has the right not to be arrested, and he accorded the suspect a right not to be arrested.
Right, so you had the special prosecutor, Kisi Jabing, in that presser. I think it must have been on Thursday, yes, Thursday or so. And this is the portion that worries a lot of people. It says there appears to be a developing trend of rather regressive and dismissive judicial decisions in respect of cases involving the OSP with troubling consequences. And it seems to us that a careful examination of these outcomes portends a disturbing specter that the fight against corruption is being hampered to the disbenefit of all of us. 4 instances will suffice. He talks about the one case the OSP applied to the High Court for confirmation of a freezing order in respect of a deceased person's state. The judge refused to confirm the order by in effect holding that the OSP had come too late since the person of interest had died and the death had distinguished. The inquiry commenced after the occurrence of death. He says the danger of the outcome is obvious. It is the fact that a person may in his lifetime acquire property through corruption and then upon the demise happily pass on the corruptly acquired property to his estate and by so doing extinguish all the scrutiny as to the propriety or otherwise of the acquisition of the property because the corrupt activities were not discovered during his lifetime. And that's why these cases that have been dismissed is of grave concern to him. Let me start with the Honorable Mahama Yariga. Honorable Mahama Yariga, good to have you stay with us again. But what would you say are your general thoughts? I mean, when you saw the special prosecutor himself for the first time holding press conference, usually they will send out, statements and things, either agreeing or disagreeing with court judgments or decisions and so on. But for the first time, we saw the special prosecutor himself holding a news conference and talking to Ghanaians. I mean, what are your general thoughts when you heard all the things that he said and so on?
Well, I mean, thank you again for keeping me on this, your very important platform. It is really good for an institution established to promote public accountability, like the Office of Special Prosecutor, to remain engaged with the population. You need to mobilize the support of the population to be able to fight corruption. And you yourself, you need to obviously be transparent about what it is that you seek to achieve as you engage with the judiciary. If you started that way and the public had the opportunity to monitor exactly what you are doing and how the judiciary is responding to you, on a case-by-case basis, you will have the verdict being passed by the public. And if the verdict keeps going against the judiciary, they will sit up. Don't forget that this is a new institution that we are setting up. And indeed, those of us who were in Parliament and part of the process of fashioning out the institution went through a lot of challenges. How do you create an Office of Special Prosecutor out of the Office of the Attorney General and Minister of Justice as fashioned, designed, and created by the Constitution? So creating the office itself was a problem. We had to go through some maneuvering mechanisms to circumvent some challenging constitutional arrangements that we have to undermine the office of the Attorney General a bit, and then to create a novel institution for fighting corruption. So that is the challenge. Now, when we finished, we tried to regulate it. So we fashioned out the act, vesting all the powers and the mechanisms for fighting corruption. And then subsequently, we made regulations to try and implement the provisions of the act. Being a new institution, being new regulations, new laws, the judiciary don't be surprised that even they have some challenge understanding the basis of what we try to fashion out. So they may not be doing what they are doing deliberately, but they may themselves just be trying to also understand the nature of the animal that we have tried to create. And that can be misinterpreted to mean that they are being used to fight the Office of Special Prosecutor. So what the Office of Special Prosecutor ought to have been doing over this period is to try to assist stakeholders understand the nature of this animal. I believe that even he, as a special prosecutor, when he assumed the office, probably has undertaken a number of travels across the world to try and study the functioning of existing anti-corruption and anti-graft institutions, how their regulations are structured and how they function, and etc. I don't believe that they have extended such facilities to the judiciary to take them around the world to engage with judges and judiciaries in countries where they have similar institutions and how the relationships have been structured between anti-corruption institutions and the judiciary in order to make the fight against corruption more effective. So there ought to be some fashioned out learning program for the judges and perhaps the Chief Justice and the Judicial Secretary, so that even they will have a specialized team of judges, so that anytime there's a matter involving the special prosecutor, they direct those cases to those specific judges, so that those judges with some better illumination will handle those cases. So I don't want to jump to the conclusion that we have a set of judiciary that is out there to undermine the Office of Special Prosecutor. Don't also forget that we have, over the years, tried to build a judiciary that is steeped in a strong culture of human rights protection. Many of the provisions that we have in the Office of Special Prosecutor Act and in the regulations that seek to enforce them are very challenging in terms of their impact on the human rights of those people who are brought before the special prosecutor. And if you have a judiciary that is steeped in a culture of protection of human rights, very often they might go in favor of human rights against some of the powers and the mechanisms that we have provided in the Act and in the regulations. But the question that really I will be asking the special prosecutor is, at this stage, he is a pioneer in terms of the functioning of the institution. And so even the jurisprudence of the law establishing the Office of Special Prosecutor, the jurisprudence of the regulations in relation to our Constitution itself will take time to develop. It will take time to develop the jurisprudence. So don't jump and give up at any given obstacle. You should appeal. Appeal against the decision of the High Court, go to the Court of Appeal, go to the Supreme Court. What the Supreme Court finally says then becomes the jurisprudence. It will take years to develop the proper jurisprudence. It will take a lot of challenge to orient the judiciary to appreciate a jurisprudence that focuses on the protection of the public purse, a jurisprudence that gets at corrupt public officers and their allies in the private sector. So that's a lot of work. And so I will urge him, he's a very intelligent, bright guy. He's been lecturing law for a while now. And so he would understand that it is not that easy to change jurisprudence over time. So I don't want to believe that there is a deliberate, contrivance by judges to undermine the Office of Special Prosecutor. It may just be that we haven't really facilitated a proper understanding of what kind of jurisprudence should be developed to be able to fight corruption effectively. Those of us who were in Parliament and debated clause by clause the provisions of the Office of Special Prosecutor Act and then the subsequent regulations that came after, we went through very challenging times. And I won't be surprised that the judges are equally going through similar challenging times.
So essentially, if there's some fine-tuning of the jurisprudence that went into setting up the Office of the Special Prosecutor and how it's supposed to relate to the judiciary, it would bring down a lot of these, what you call conflicts between the two. I guess that's the point you're making.
Now, that's basically my point.
Right. Now here's the thing. Now listen to this is the part that bothers him a lot, and it bothers a section of the public as well, because these are the similar sentiments that were expressed by Martin Amidu, based on which he decided to quit his position. Now it says, blah blah blah. Okay, it would be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated or prosecuted and who should not. The danger of this startling decision to all of us again is obvious. A judge has granted two persons immunity from investigation for suspected corruption and corruption-related offenses, and hence immunity from prosecution. This decision opens up a calamitous deluge, as every person under criminal investigation would be encouraged to take out suits to injunct investigations and prosecution bodies from investigating and prosecuting them. The real and present danger looms largely on the consideration that by so doing, persons under investigations would conscript the judiciary to clothe them with immunity from investigation and prosecution. And it says, members of the press, I do not intend to sound as though I'm predicting doom. However, with this development, it would not be long a suspected murderer or armed robber would boldly walk to court with the unthinkable prayer that a court should injunct law enforcement agencies from investigating and subsequently prosecuting him. Now remember that the Office of the Special Prosecutor is founded on 4 pillars. So one, they are supposed to prevent. So in cases where they have to freeze your account and so on, so you don't go and dissipate it, they'll prevent it. So prevention, and then if they can't, they investigate. If they can't, after investigation, they prosecute, and then they recover. That's the 4th pillar, recover assets as and when it becomes necessary. But the prevention part, questions are being asked. Why is it that when it has to do with what you call the big men or big women within this administration, all of a sudden they run to the court and get some immunity? But the smaller fishes aren't getting that. Help us appreciate. I mean, you're a lawyer. You've gone to court several times. Is there anything to worry about, or these are normal court practices in law?
Well, I think that we should be mindful of the special mandate of the Office of Special Prosecutor. It is not an office that really has a very broad mandate, contrary to what most people think. This is an office that focuses on public officers and private sector operators acting in collaboration with public officers to commit corruption-related offenses. And the vast majority of the corruption-related offenses are expressed in the Procurement Act. So there is an extent to which the Procurement Act and then also, unexplained wealth are the special focus of the Office of Special Prosecutor. And with this understanding that, there's some limitation in terms of the mandate of the Office of Special Prosecutor, regulations have been enacted. And I think that the OSP must be very careful how they proceed and pay attention to the language of the regulation that govern their functions. I recall that in the case of Cecilia Dapa, when the OSP went to court and the court gave rulings against them, and they went to town complaining about the courts. I drew attention to the fact that the OSP office itself had not complied with the law, because the law was clear on the time frame within which to put in applications, the time frame within which to carry out certain actions. And so if you yourself, you don't pay attention to the details of the law governing how you function, you cannot turn around and then, blame the judges when they draw your attention to the law and then what it says about how you carry out your responsibilities. The language is very, very clear. The regulations are clear. Don't forget that most of these regulations were presented to us at the time that Senior Martin Amidu was still special prosecutor, and he's quite meticulous in his ways. And so the regulations and the laws are quite clear. And so the Office of Special Prosecutor must, in all cases, demonstrate they themselves that they are acting according to the regulations and the laws that set them up.
Okay.
And that they are focusing on exactly what their mandate is when it comes to the law that has set them up. So if they did that and they were facing obstacles before the courts, they should appeal. They should appeal until they get to the apex court, which is the Supreme Court, so that the Supreme Court can provide clarity in terms of what the rules should always or should be.
Yeah, but Honorable, the challenge is
provisions.
Yeah, but I totally get what you're coming from, because that's the reason why we have with the hierarchy of the courts. But I've also heard some people say by the time you get to the Supreme Court, everything's well. I mean, look, if it's some money you are chasing, you're trying to prevent the person from touching the money, or you're preventing somebody, or you're trying to confiscate somebody's property. I mean, that's essentially speaking. By the time you get to the Supreme Court, to get the Supreme Court to make the pronouncement, the person has probably, given the property to whoever they need to give it to. And so what have you done? If indeed the whole essence for setting this thing up is either to prevent, or if in cases where the person has already appropriated whatever assets there is to appropriate whatever assets to the person, you want to recover it. But by the time you get to the Supreme Court, the person has done something with the assets. How are you going to get it back? I mean, that's been one of the challenges. It's one of the worries.
Hello, can you hear me?
I can hear you, Honorable. Yeah. Can you hear me?
Okay, so let me say that.
Yes.
I can hear you.
Yes, I'm listening.
Let me indicate that, the saying that corruption will always fight back.
True.
Definitely. You don't expect people to just sit back and allow the Office of Special Prosecutor to expose them, to arrest them, to be able to get to their assets. So they will fight back, and the place where they will fight will be the courts. So I expect to see the special prosecutor fighting hard in court to develop the jurisprudence, to develop clarity. If you suspect the High Court of conniving with suspected cases, the Court of Appeal is likely to expose the High Court. And if the Court of Appeal doesn't do it, the Supreme Court is likely to expose the Court of Appeal and the High Court. And then we will have clarity in terms of the precedents.
Yeah.
I believe that not many people have confidence in our judiciary as it is now, for reasons best known to them. But I retain confidence in our ability to fight and keep all institutions in check, including the judiciary.
Okay.
By the clarity of our legal arguments in court.
Okay.
And our advocacy of the right position.
Right.
So for me, at this stage, all I can do is to urge the Office of Special Prosecutor to continue to fight in court and not to give up and to use the media as well to help us discuss these issues and put the judiciary in the spotlight.
Okay. All right, Honorable, thank you so very much for your time. It's been wonderful talking to you. But just a quick one. Should he resign or stay there? That's just a quick one. Should he resign? Because already there's pressure on him to resign if he knows he can't do the work. Okay. I think I've lost that, the Honorable Mama Yariga. So let me come back in here. Mr. Joe Jackson has to leave us. He has other engagements to attend to. So he will give us his general thoughts about what he also heard the special prosecutor say, and then he will leave us. And then Honorable Mutalaina will he will give us his take, and then we'll move to the MPP and constituency elections. Boss, but what do you also think?
Well, first of all, I have to say this, that Honorable Ayariga is being kinder.
Or he's being diplomatic?
No, he's really being kind to the judiciary. And not to the, he's being kind and very kind to the judiciary.
Right.
And I will just quote one proverb, right? When the tadpole comes from under the water to tell us that the crocodile is dead, who am I to doubt him?
Right.
Right? And me, I'm old school. I used to watch a lot of James Bond films in my youth. And there was a saying from James Bond that I loved. He says, first time is happenstance. Second time is coincidence. Third time, enemy action. The special prosecutor has laid out first time, happenstance. Second time, coincidence. Third time, fourth time, even a fifth time. And he is the tadpole coming from under the water. I have to believe that the impression some of us have that this our judiciary, we should be careful, it must have some substance. This is definitely smoke. It must have some substance. So whereas I'm not a lawyer, so I can't say, it's very difficult for me to speak to the specific instances, but as a layman, I will ask, one of the cases that I didn't understand as a layman. The man is dead, so what? We can still investigate how he got his money.
Right.
So he's dead, so we should allow it to go. I will ask why. It's the public purse. If he took the money illegally, I want that money back in my public purse. The fact that he's dead means what? As a banker, knowing anti-money laundering laws, somebody has money sitting at home, and you want to investigate, you should be allowed to.
Right. But it's also about the law. You've got to go through the legal process.
Yes, but you see, the law should serve us. And he's detailed 5 circumstances. That's what I talked about. Happenstance, coincidence, detailed specific circumstances.
Right.
I say that and then added to that, I'm not a great believer that any of our institutions should not be criticized. That's a recipe for disaster. We should criticize, but we should criticize with decorum. Right? There should not be insults. It should not be personal. But we should be able to criticize and say, I don't agree with you.
It's interesting. I've already heard some people say that the Kise Jabing is trying to blackmail the judiciary.
Why is he trying to blackmail the judiciary? He's quoted instances. What I would like is to somebody to come out and rebut what he's talking about. But as at now, all I know is that, again, the tadpole has come from under the water to tell us that the crocodile is dead. I say, let's listen to the tadpole. Right?
Okay.
Let's listen to him. And I think that is important. Okay. The other thing also is, I'll tell you straight away, he shouldn't resign.
It should stay there.
It should stay there. You see, and when we say first time is...
But he's under pressure to deliver.
Yes, but he has to. Listen, we've seen citizen vigilante go and make similar issues and resign.
Right.
It didn't change anything.
True.
If listen, he's a strong man. Look at him.
This is all kinds
strong man.
All kinds of hurdles have been put in his place.
Yes, he should fight it. And he should know that some of us who believe that corruption is actually the biggest problem we have in this country, and not even economic mismanagement,
right,
will stand behind him.
Okay.
Yes.
Right.
Yes, and he shouldn't resign.
Okay.
Please, sir, if you hear or listen, I say, don't resign. Fight it.
Okay. Mr. Joe Jackson, thank you for your time. And have a great day.
I will.
It was really nice.
I will. It was great.
It was a pleasure having you.
It was great.
And so we're done with the conversation. No, well, you've given us your thoughts about the Kisei Jabi. I'll come to me, the Honorable Murtala Mohammed. Let me read a few messages and I'll come to you, the Honorable. This one here says that Mr. Joe Jackson has made my day. I think his thoughts about the Kisei Jabi matter is obvious. Kisei Jabi should stay and not go anywhere. He must fight corruption because corruption is one of the biggest problems we have in this country. That's coming from Nanaya Ichampong. This one here from Israel. Israel says that Mahama Eriga is a very astute lawyer. I like the perspectives he shared, but I can also understand why he's being diplomatic with his criticisms of the judiciary. He didn't quite criticize the judiciary. He was just saying that maybe the judiciary and the office of the special prosecutor, must, how do you call it? There must be a proper relationship between the two bodies. I think that's the point he was coming from. So I guess these are some of the statements, some of the messages that you sent to us. It's 024. I'm going to send you the number. It's 0249 155 0249 155 We're discussing this special prosecutor held a news conference on Thursday. Was complaining about, not complaining, but was raising issues with the roadblocks or the hurdles that have been placing, before him, making his work extremely difficult. He says some judges, it appears, are very committed to making sure that he doesn't succeed, and that's where we went. So I'll get to the Honourable Mutale's concluding remarks. His remarks on this matter, and then we'll move to the MPP's constituency elections. Extremely important. Please go ahead. What do you make of what Kisei Jabing has said? Are there any things you agree or disagree with him? Are you so one of those who thinks that he's blackmailing the judiciary? He's been too overly critical of the judiciary?
Well, Muru, I had a position against the establishment of the office, and I made my position very, very clearly.
Okay.
I never had any problem with the establishment of an office that was to investigate, if you like, political corruption.
Okay.
I never had any problem at all with that.
Okay.
Because it is true that corruption is endemic in this country.
Yeah.
It's true that some politicians are fantastically corrupt.
Right.
And I have said that 80% of the problems we have in this country are occasioned by the conduct of people, unfortunately, that a particular institution that I happened to be an active participant, and when I say this, I mean politics.
Right.
I'm a politician, but I'm sorry to say that some politicians are fantastically corrupt. And a lot of the problems you have in this country is because of the conduct of people who are supposed to be politicians.
Okay.
That is not to say that other ordinary citizens, civil servants, public servants are not corrupt.
Right.
They are some public servants, some civil servants, some religious leaders who are fantastically corrupt. The reason why the focus is on political corruption is that as politicians, we have a privileged opportunity to put in the necessary measures or mechanisms to ensure that corruption that permeates through the fabrics of every society in Ghana are brought to stop.
Okay.
To that extent, the office of the special prosecutor is considered to be one of such measures or steps taken by the state. when I had problem with that office, I was wondering that an office that was established for the purposes of investigating political corruption was going to be, if you like, duplicating, or if you like, quadrupling the work, or if you like, conflicting the work of the Ministry of Justice and Attorney General. Because I felt that the work the Office of the Special Prosecutor was coming to do, the Ministry of Justice and Attorney General was already doing that.
Okay.
And I was particularly worried that he wasn't given that much powers.
Okay.
Because a special office of the Special Prosecutor investigation can be curtailed
Right.
by an action of the Ministry of Justice and Attorney General.
True.
So
where
that
lies the independence?
Where lies the independence? And I felt that it was much ado about nothing. That it was what I described as cartoon scenario reality. That, oh, okay, we have set up an independent office.
So you, right from the get-go, you didn't believe in the office of...
Yes, I didn't believe
in the setting up of the special
I felt that you can't set up office of that nature when you have not given it that absolute independence, that it is still doing work that the Minister of Justice and Attorney General and the Minister who is a political appointee can dictate as to what final...
So did we go or did we come?
So that was why I had problems
with
it.
I get it.
I felt that if we wanted to do such a thing, we needed to have given them that absolute independence. Or decouple the Minister of Justice from the Minister of Attorney General.
Right.
If we did so and feel that those who are there are not political appointees, it will make a lot of sense to me. At the time, I asked it to continue to make sense to me than what we did. So I felt that we needed to decouple the Minister of Justice and from the Minister of Attorney General so that we can have one single independent body that was clothed with the authority to do some of this investigation, even including political, corruption.
So it looks like the chickens. So it looks like the chickens have come home to roost.
Again, everybody knew that Mr. Martin Amidu appointment was just to witch hunt NDC people. Because of the position he took. Because of the position he took with regards to NDC. What happened to it? Absolutely zero. Now, Mr. Martin Amidu was hounded out of office by President Nanado and his family. There is no question at all about that. They never had any problem with Mr. Martin Amidu when he was investigating his nephew, Honorable Ayarga. But they had problems with him when he attempted to investigate stealing that was perpetrated by people in government. Now, this gentleman was also appointed. There are people who had problems with even his appointment. Because people felt that he was a friend to Gabi Ochebdako, who happens to be the de facto prime minister of the Republic of Ghana. So people had problems with him. Now, when he began to assert his independence, once again,
his troubles began.
He got good, just like Mr. Martin Amidu. So I think that, like he said, we all wish that he maintains the independence. And for him to come out to make the statement he made, I think we should take it seriously. But you see, who doesn't know in this country the judiciary is corrupt? Who doesn't know? As a matter of fact, the judiciary is one of the corrupt institutions in this country. Look, I'm a politician, and I feel no shame to point out that politicians are corrupt, or some politicians are corrupt. So some judiciary are also corrupt. In fact, Justice Georgina Wood herself, then at that time she was the Chief Justice, publicly stated that the judiciary was corrupt. The CDD, in their Afrobarometer report, identified judiciary to be one of the institutions that was profoundly corrupt in this country. We still remember, we haven't forgotten Anas's expose. When people would have to take bear to be able to dispense justice. Take goats. These were all, to drum home the fact that just like any other institution in this country, the judiciary was also very, very corrupt. The reason why corruption or alleged corruption within the judiciary is scaling is that they have a privileged position to determine your freedom or otherwise. They have the singular, exclusive authority to determine whether myself or you should be a free man walking or not, as and when we have a case against us, or we even bring a case against anybody. Now, when you have people who serve as an arbiter between what is right and what is wrong, between the freedom of citizens or otherwise, they themselves engage in corruption. For me, it is extremely worrying.
Okay.
That is why
Okay.
we think that we must take his position very serious.
Okay.
And if I will call for an independent body
Right.
to investigate the allegations he's leveling against the judiciary, I think that there should be an independent body, because we can't get that sincere position on this from this government.
I get it. Also, I think that would be, how do you call it, the conclusion or the end of the conversation on Kisei Jabeng.